Okay, what are we covering today? I'm going to give an overview of what it's like to work with teenage boys, and mainly the systems that are involved in framing the trauma that they've endured, both in their countries, on their way here to the US and in the United States. I'm going to give just a quick overview of tips when you're interviewing teenage boys and what to consider explicitly when you're speaking with them. I consider declarations to be the intersection between storytelling and advocacy. I'm going to give a few sample frameworks to consider when you're drafting an SIJS declaration, an asylum declaration, and a U visa declaration, some practice pointers and pitfalls, and then I'm going to leave some time at the end if anybody has any questions. I'm not breaking any news to any of you on systems that are affecting teenage boys all over the world. They're living in places that are dealing with a lot of different stressors. I've listed a few here. This is the tip of the iceberg, but anyone who's been in this space, even if you're a new practitioner, is keenly familiar with all of the different systems that are affecting teenage boys and really the trauma that results from having to live in those systems. What the literature is showing that's been pretty relevant in the last 25 to 30 years, and mainly for working with unaccompanied kids in the last 10 years, is that these systems affect teenage boys in a very significant way, in a very unique way. There are, of course, going to be exceptions to the way these systems affect all kids, and especially boys, but the trend has been that this trauma as a result of having to live in these systems is going to affect what's called neurodevelopment and psychosocial development. These are impacts that happen very early in a boy's life, going from being as young as several weeks old to early adolescence and into adulthood. And extreme cases can lead to what's called hyperarousal or dissociation. I've written the definitions there. This is a pretty interesting publication that was published in 2009, so before the latest phenomenon in unaccompanied kids' arrival to the US. This has been a very well-documented phenomenon here in the US itself, especially among boys of color. These pretty severe cases can lead to what would otherwise be ordinary conversations between two people having an extreme impact on a boy. And it's just something that should be at least considered explicitly when working with boys. The term of hyperarousal means that they have an elevated heart rate, an elevated body temperature, constant anxiety. Dissociation is when they have that traditional fight or flight or freeze response when they're dealing with a stressor or a traumatic experience. And that has long-term effects on both their physical health and their mental health. With reference to boys in particular, the systems that affect their lives from an early age end up sort of conditioning them into thinking that they should be strong and silent, that they should emphasize toughness and minimize vulnerability. And these systems consider overt expressions of power, control, and violence as a way to express yourself. And anything that has to do with any sort of weakness is to be at least muted or minimized as much as possible. And the result, especially for children who have been living in these systems for a very long time, is that they end up becoming very timid or reluctant to speak about their traumatic experiences with frankly anyone who they don't perceive as trustworthy, with a practitioner who's only now beginning to work with them one-on-one, with social workers who have been assigned to their cases in an ORR shelter. Boys might not be as willing to talk about all of the uncomfortable things in their life because they've been conditioned not to. And our role as practitioners is to, before we get into the art of writing a declaration, is to just understand how to approach conversations with teenage boys about the traumatic experiences that they've had. And so part of this presentation is to just give some just practical tips. A lot of you may be familiar with these, but I think it's important to be intentional about this practice. So that way, whenever you are working with a teenage boy who just becomes quiet during the first conversation, to know how to approach that interaction so that you can build the trust that they'll need to feel comfortable working with you and moving forward. Practical tips. It's important to be explicit with children up front, particularly because they're familiar with their personal lives. And if we outline our roles, if I outline my role explicitly, then they'll have a better idea of what I want to accomplish with them. Being intentional about talking about their trauma, especially when you can give them a sort of advance notice that you're going to be talking about it, will work in your favor in the long run, because then they'll know that they're going to talk about something that they might not want to at first, but that they'll know that will be helpful to them throughout the ongoing work with you as a practitioner. I mentioned this to be willing to discuss the possibility of treatment with a boy, knowing fully well that they might not be receptive to it at first, just because either might not have been exposed with any mental health resources in the past, or they might not trust you yet. And so just be willing to mention it, and then just be ready to either not connect them right away if you feel like you need to spend more time to get to know them and understand their situation. But if you feel like they are ready to consider the possibility to connect with social services teams in your organizations or with an outside provider and get them connected with any treatment that they might need. Really, the third and fourth bullet points are relevant. They're related to be patient and to give them the time and space that they need. They may have never been asked about their trauma or mental health before, and even if they might have lived the experiences, they might not necessarily be ready to speak with you about them. I also mentioned this one just because for all of the time that we spend being explicit with all of the traumatic system, all of the trauma and the systems that cause the trauma have on boys, with all kids, but particularly with boys, especially if they've been basically conditioned to minimize any long-term effects that the trauma may have had. Treating them as dynamic is really an excellent way to get to know them personally and to basically build trust. They're not defined by their trauma, and they may have goals and aspirations that are completely unrelated to it. And I find that to be really helpful when working with them, to basically just learn about how they're doing in the moment, how they're doing in school, how they're doing living with their sponsor, what it's like to be in the United States, what are their favorite things to do, just not just to lighten the mood, but to also just remind them that you're not just interested in learning about their trauma. There's a pretty well-established term called cultural humility that's pretty relevant in this context. And that basically just means that you should not try to assume that you know everything about the person's background, even if you might be familiar with many cases from the child's country or from the town that they may have lived in before they came to the US. It's not necessarily accurate to think that they have the exact same experiences that your previous clients had. And so just to be open to learning more about who they are and where they're from will not just build trust in them, but also just keep yourself humble in learning about what systems are going to be applicable here and how you're going to basically tell the story with the idea that you have something to learn too from the kid. Just to think practically again, the way that this term unfolds in your day-to-day practice is in a myriad ways. To think about when you meeting with the boy for the first time, how you're going to arrange the meeting, where it's going to be, who's going to be sitting where, how much lighting there is, where you want them to sit, being mindful of scheduling, and if they have an obligation that they feel is super important that they don't want to get out of, whether it's school related or sport related, or if they're working, to just be mindful of the schedule. And even if it might not be convenient for you, to just be aware that it's probably the only time that might work for them. To ask questions outside of the case, and like I mentioned, just to be sure that they get a sense that you're curious about them as a person and not just as a person who survived trauma. Court hearings, to be humble about how they dress, knowing that they might not be able to afford new clothing, or that they might not be able to travel to a place to buy clothes, to be able to basically have a conversation about what might be expected of them in a courtroom and how you can work with them to be able to prepare for that sort of expectation. Comfort level speaking in public, even if they might have had really traumatic experiences, that doesn't necessarily mean that they're willing to talk to anybody in a position of authority with them. And I definitely have noticed in my own practice how some of them sort of get really quiet when they're in a courtroom speaking with a judge, or if there's another person wearing a suit, how they might not necessarily be as forthcoming, even about basic details about where they live or what language they prefer to speak. So those types of details are just important to keep in mind when you're focusing on your practice through a cultural humility lens. Use of interpreters, this becomes especially relevant when you're working with boys who speak an Indigenous language, and being aware that there might be a system that emphasized learning Spanish over their Indigenous language, and that valued Spanish over their Indigenous language, and also just letting them know that you are aware that they do speak that Indigenous language, and that you want them to feel comfortable speaking in what language they speak the best. Communication is really like an expanding area, especially in today's world, knowing that kids feel very comfortable texting and sending photos with their smartphones, and not necessarily putting their thoughts in a letter and mailing it to them. So just being mindful of communication in writing and on the phone, just knowing what ways you can be humble about communicating with them, knowing that they might not necessarily be exposed to the systems that sort of emphasized writing a formal email. Trust is one of the goals in employing cultural humility. The more time you spend with a boy, the better the relationship tends to be. I've already mentioned some of these. Ask where in the room they prefer to sit. Remind them of the applicable confidentiality rules. This will vary from state to state, but just let them know that conversations generally between an attorney and a client, or a staff member and a client, are confidential. And then be sure to emphasize any exceptions that might apply in your jurisdiction, just in case it will affect the conversation moving forward between yourself and the client. Take plenty of breaks. Super important, especially with a boy. If they start to clam up and not answer questions, don't insist that they give an answer. Sort of get a sense for their comfort level in answering a question. And if they need a minute or two to gather their thoughts, I think that's probably an appropriate thing to do to make sure that they can feel comfortable answering. And I've already mentioned this. Enjoy it, end with something positive. Talk about school, favorite sport, TV show, anything that you're gonna give an impression that you're not going to dwell on their trauma. For those using an interpreter, if the interpreter is going to be in the room, I recommend that the interpreter sit in between you and the kid, just so that they're going to communicate clearly with the kid. And so there's no miscommunication based on lack of distance. As the practitioner, you'll explain the purpose of the interview to the interpreter. So just emphasize your role up front, what the interview is going to be about. Describe the role of the interpreter so that there's no misunderstanding about what the interpreter is supposed to do or not supposed to do. Make sure that the interpreter knows to use the first person, because the interpreter is going to be speaking as though the kid is speaking that language that the interpreter is using. And the rapport should be between the attorney and the child, and not necessarily between the interpreter and the child, just because that might not be in a relationship that extends beyond one meeting. Really important for the interpreter not to engage in any independent conversations, because those are not confidential, and the child might not necessarily want to disclose all those details to an interpreter. So just from the outset, just let the kid know that there shouldn't be any one-on-one conversations happening with the interpreter. I've already mentioned something similar to this, but the interpreter should ask the kid to sit down and repeat information to ensure accuracy. It should be maybe 2 to 3 sentences at a time. So this might take some practice, particularly if you might have a boy who is ready to be very forthcoming about details, to slow down and sort of give smaller chunks of details so that the interpreter knows exactly what was said, and to be able to ensure that they can interpret the entire information without leaving any gaps or any misunderstandings. In a declaration, there are multiple purposes. One of them is to tell the adjudicator your client's story and to help them understand the client's case. What is this case about? Is it an SIJS case? Is it an asylum case? Is it a U visa case? And each of those has their particular nuances. And so it's just letting the adjudicator know what is this case about, and what am I going to read further down to be able to understand what's happening. Just as a legal matter, you're going to state the facts that are going to support the claim. If you have an SIJS case, what requirements are you going to satisfy in the declaration? And similar to an asylum or a U visa, what are the facts that are you going to use to show that the claim has been met? The third one is to take control of the narrative, is to basically be in the driver's seat and to let the adjudicator know what details are important and why, and how are you going to frame them to the adjudicator, so that the kid is in the best position to understand why your client should be granted that relief. And to persuade the adjudicator, this is not just like showing what facts are relevant to the claim, but what additional facts can you mention that'll sort of tug at the heartstrings of the adjudicator to let them know this is a compelling case, and grant is in the client's best interest as a matter of discretion because of these reasons that are somewhat related to the claim, but also beyond the requirements. In an SIJS case, there are several elements. There are the elements of abuse, abandonment, and neglect by one or both parents. And those are state specific, so you have to look at the definitions in your jurisdiction to know what the definitions are and which ones will apply in your case. That it's not in the child's best interest to be returned to their previous country of residence or nationality. So what sort of compelled them to leave their home country, and why being forced to return is not in their best interest. And there's the relevant statutory support for the definition of an SIJ. The overview that I give when I think of an SIJS case is to basically give an intro at the beginning, right? Just say, who am I? I am, my name is X. I was born on this date. I was born in this country. My parents are X and Y. Be very, very straightforward. This part is pretty easy to go through. If you're interviewing a kid, this part shouldn't take that long unless there are special circumstances that might require a little more finesse to be able to understand what's happening. Life in home country is in a paragraph on its own. Who the child lived with, what life was like. When it comes to interviewing a kid, this might be a part that takes some time, depending on what happened and who they lived with and what their life was like. Might take 20, 30, 45 minutes if they're willing to speak the first time around, or it might take longer depending on what happened with them, with school. Thanks, Sabrina. Providing an SIJS declaration is not a part of my practice. What's the benefit of providing it? Some jurisdictions mention in their statutes that a declaration is sufficient to support the findings, basically as a way to avoid having to testify during the court hearing. And I think the spirit underlying that statute is so that the child doesn't necessarily feel compelled to give all of these traumatic details to a judge for the first time. And I've begun preparing declarations, and where appropriate, I've submitted them, but in other cases, I don't. I prepare the declaration, but I don't submit it, just to be able to sort of create an outline for myself so that I can have that ready in case the judge actually wants the kid to testify. Relationship with the parents. The description of the abuse, abandonment, or neglect. If the boy has a positive relationship with one of the parents, I think it's actually really important to outline that explicitly, and to explain what role that parent had in that child's life, if they were always living together, or if the parent came to the US years before the child did. I think it's super important to let the judge know of what that relationship is like. Decision to flee, why the child decided to flee their home country, and this could be for all of as a result of the systems that I've outlined before, whether it was due to violence, whether it was due to the lack of opportunities, the inability of anyone to protect them from danger, or if there are opportunities here in the US, you can frame it in terms of the opportunities they have here in the US and that they wouldn't necessarily have if they were forced to return to their home country. And life in the US, who are they living with? Are they in school? What grade are they in? How they've enjoyed any particular subjects, if they're in a sport. Those are the type of additional facts that I mentioned, not just for the best interest, but to also just paint the picture that they're a dynamic person. I have a hypo here. You have a consultation with Roger, who's a 16-year-old Guatemalan boy. You ask Roger who he lived with when he was in Guatemala. He says both parents and a younger brother. You ask how it was like to live with his parents, and he shrugs his shoulders. You repeat the question, and Roger puts his head down. What steps do you take to encourage Roger to give details about his life? And feel free to add to the chat. If you're meeting him for the first time and he's shrugging his shoulders and putting his head down, what are some tools you could use to basically make him comfortable with speaking with you? Offer a break, glass of water. Good, right? So thinking of the setting that you're having the consultation with, right? The space, making them feel like they can take a break is great. This example of home life. Did you talk every day? Did you share meals together? Right? Be more specific about the day-to-day routine. You clarify the role and purpose of the questions. That's excellent that you mentioned. This is why I'm asking. I'm not asking because I want to make fun of you, or I'm going to share this with my next door neighbor. Like, I'm asking for a very specific reason. Yeah, so yeah, I would approach it in basically the same ways. Take a break, let them know that if they don't feel comfortable answering now, that we could always either reschedule and meet again when they feel more comfortable. Ask him to describe what a typical day looked like for him in a home country, get him more comfortable with talking about less pointed topics. Yeah, talk about something that's not going to make him necessarily uncomfortable. Like if he has any favorite thing that he'd like to do in his home country that he hasn't done yet here and that he's looking forward to. Christina asks, is there a time you would consider going on to the next question and coming back to the question later? It might be if you feel like he is ready to move on to something, but if you feel like he's not necessarily ready to answer any questions, then I think it might be relevant to just stop and give him a chance to gather his thoughts. If he mentioned something that made him smile or made him laugh, maybe you go back to that and get some more details to like warm him up a little bit, and then go back. But if he shut down, then I don't know if going to another topic is useful at that moment. Acknowledging body language, asking him why he's shrugging his shoulders and putting his head down. Yeah, I think being explicit might be a useful thing. If they're reluctant to talk, maybe offer to go on a walk together around the block. That, yeah, again, adjusting the space to make them feel comfortable. If his parents punished him, yes. If you get the sense that there's some trauma there between Roger and his parents, I think that's going to be relevant to know. I've used a feelings wheel at this point. Do you use words? Yes. I've seen charts and wheels to basically encourage them to point to which one might best describe how they're feeling now, or what they felt like when they were living with their parents. Yes, more specific questions. Thank you. Okay, later in the meeting, Roger shares with you that he dropped out of school at 14 because his parents said it was a waste of time, and that if he didn't work, he'd be thrown out of the house. When you ask if he would have stayed in school if it were his choice, he starts to cry. How do you respond? It might be similar to what we've already talked about, where you adjust the space, or you consider, well, would you like to talk about how you're feeling right now? Yes, bring it back to the meeting and give thoughts about what's going on right now. Offer a tissue, remain quiet until you get out and something. I'm sorry for your experience. Yes, validate feelings, show empathy, asking if he needs a break, if time allows, let him. Yes. I've had cases where again, going back to hyperarousal, asking a question that I think was otherwise innocuous that ends up becoming a time to pause and let them sort of gather their thoughts and then come back a few minutes later, or maybe 15 to 20 minutes later if they feel like they need, if it's appropriate. Offer water, right? If in their home country you're struggling for food or something else. Yeah, I think eventually we'll talk about something that they may have struggled with. But going to this particular issue about school, I think that that I would give them time to reconvene and gather their thoughts, and then afterward, once I feel like they're ready to speak again, I ask about school again. And then you would also ask about other like general conditions about their life in their home country. But rather than ignoring this topic and going back to it later, maybe talking about it and finishing the thought before moving on might be relevant in this case. These are all great, like practical things to do. Thanks for those of you who shared. An asylum declaration looks a bit different. These are the elements. There's the persecution element. There's the nexus element based on the 5 protected grounds, and there's the perpetrator element based on a government or a non-government actor. The structure and format looks somewhat different. There are just no formatting requirements. If you're going to file this in immigration court, there are generally no formatting requirements, other than the fact that you just have to include a page saying that the declarant is swearing under penalty of perjury. Draft declaration in short numbered paragraphs. Short numbered paragraphs is good, not just to when you're preparing it with the kid, but also when you're going to be presenting it to the judge, so that they're aware of the specific facts, and supposed to say large blocks in the declaration. They'll see smaller chunks that they might be able to best readily identify than a larger paragraph. There's no set length. One just tip is to use strong topic sentences. What is this paragraph going to talk about? Is it going to go toward an element? Is it going to go toward a particular issue that's going to be complicated for the judge to understand? Is it going to be a tug at the heartstrings paragraph where you talk about something in addition to the elements of the asylum claim? You maximize the strengths and minimize any potential weaknesses. And here I basically think about not just the elements like who did what to me, but also don't dwell on anything that the judge might be either confused on or might not necessarily agree with you on, and particularly if it's going to be a complicated nexus. Don't dwell for many paragraphs about the nexus if you feel like that's going to basically trigger the judge in thinking that it's like you're overcompensating for something that you think is probably a weakness. It should read like a story, right? A beginning, a middle, and end. One framework is chronological, right? From the birth of the child to the present day. That tends to be a pretty default framework, because an adjudicator will have probably an easier time understanding what it was like when the child was first born, than when a major event happened, and then what caused them to flee, and then afterward what their life is like in the US. So chronological is a good default, but it's not the only framework that you can use when you're drafting a declaration. You can focus it on people. You can focus it on who was there your whole life when you were living in your home country, and what happened to that person, and why did that person's absence affect you so heavily. So you can frame it in terms of people, or you can frame it in terms of events. Like, when I was young, I did X, Y, and Z in my town. And once the war started, I was unable to to participate in these events. And that is why I'm now here in the United States. So you can frame it in terms of events. A theme is something to consider when especially if the kid keeps bringing up something that you may not have anticipated beforehand. If there's a particular person who is the person causing the harm, and you can frame it in terms of the child's vulnerability. That can be a part of the theme. Right? I was always protected by my older brother, and then there was a government crackdown, and I can no longer depend on my brother because he was killed. So I'm now extremely vulnerable because there's no one there to protect me at home. Set the scene. So using sensory details, I think, is a good one to consider, to place the adjudicator in the client's shoes. I think characters are good frameworks to consider. Who do you think it would be the hero in your client's story? Who's the villain? Who's the victim? And so those are ways to think about how to frame this the declaration, knowing that it'll be heavily dependent on the kid's facts, but also just how you are going to best tell that story. Here's how I think of the declaration intro, similar to the SIJS declaration. You give basically an overview of who's who, what you're trying to accomplish in the case, and you could mention protected grounds up front, depending on if you think that they're going to be a prominent in your declaration, so that the judge is aware of what you're going to be talking about. So here, this is a chronological framework. You're going to mention the early life. What was life like before the traumatic event? My first years of life were stressful, but I relied on my older brother for support. Then, as time went on, things changed. Right? The government cracked down on student protesters. This first, worst, last is another way that you can frame persecution in particular. What was the first instance of the persecution that you experienced? What was the worst that happened? And then when was the last time it happened? Particularly if they might not know how many times certain things happened, because they happen with such frequency, or they have long-term effects of the abuse that affect their memory, and that they might not be able to pinpoint an exact number of times. I think the first, worst, last structure is actually kind of useful. If you're going to be describing something, I would a particular assault, I would keep it clinical, mainly because you don't want the adjudicator to basically impeach your credibility on inconsistent statements. If there are outside documents that you're going to use to support that, then it's important to keep those consistent. But even if the declaration is the only thing, I would keep it clinical, just mention what happened, so that nobody can basically question the like veracity of the instance. You have to establish that the protected group was one central reason for the harm, right? So you mentioned that explicitly. The government's targeting me because I'm a student and because I protested against them. If you heard particular language from the persecutor, quoting them might be useful to you, so that way the judge is aware of exactly what the perpetrator was saying, and not necessarily a summary of what was said that might not necessarily capture the essence of the exchange between the persecutor and the kid. Government's unable or willing to protect, that just goes toward the element of toward the asylum claim. Decision to flee, which I've already mentioned before. Review record for any prior statements, and you have to make sure if there's any, if there are any inconsistencies, that you can clarify them, or if you have the outside documents, then you could make sure that they stay consistent to what they are. So you should review your notes. If there was a credible fear interview, I know when we're working with UACs, there isn't, but there might be one of a parent or of another family member who you might want to just cross-reference. The I-213 is going to be pretty key if the hearing goes before IJ, mainly because the ICE TA is going to basically rely on that when they cross-examine the boy. The application, and then if there's any other forms of relief, to just review them and make sure that they're consistent. Ask questions to establish the protected characteristic. So this goes back to interviewing a teenage boy. Why did the abuser target you? What circumstances led to them targeting you? When did they begin? So being very explicit about why, and was it more dangerous for you? Why did the persecutor target you more specifically? And is it more dangerous? For some of these examples, there's harm from gang members. And did anything happen after you said no to the people who threatened to harm you? Did things get worse? So that's just questions to consider. Anybody have any questions on the asylum declaration before I move on to U visa? For those of you who know, U visa is a form of relief for those who have suffered harm from various lists of crimes here in the United States. It's a way for the non-citizen to become a lawful permanent resident if they meet certain elements, mainly participating in the detection of the crime and being willing to cooperate with the investigation. They should have suffered. So Karen asked, what if the child doesn't specifically know why, like in gang-related asylum applications? It's a good question. I think I would focus more on possibly asking the child what other family members told them, and if that might give you more information, then you make a note of that. If the child feels comfortable with you speaking to another person, like a family member, about that, then I think that you should get the child's consent in writing before you ask any specific questions, so that way they're aware that you're going to be speaking to another person. And then when you do speak to the other person, just remind them that if you are going to be representing the child only, that those statements are going to be confidential, and that they're not going to be revealed unless certain exceptions apply. So I think of reaching out to another person would be my approach. So there's what if the child is being targeted because of sexuality and has trouble talking about it? It's a good question, and it goes back to interviewing. And if you feel like they're not necessarily comfortable speaking about specific instances of harm, then asking them who might be a person that they feel comfortable with talking to, that would that you can find, if it's either another staff member in your organization or finding an outside person who is a professional in that area that might be able to prepare a psych evaluation, would also be approaches that I would take. And I think just being explicit, not necessarily making them feel like guilty for not telling you, but just leaving their options open about finding somebody who they might feel more comfortable speaking with. For victims-based work here in this space, I feel a little reluctant using the word victim. I tend to use the word more survivor, because of not just the trauma that they experienced in their country, but the fact that they're actually trying to move beyond that trauma and not defined by it. And so when working in a U visa context, similar to all survivors who may be vulnerable, they might not necessarily want to participate or feel uncomfortable participating with the justice system for a variety of reasons. And some of them overlap strongly with the systems that I've mentioned earlier, but also ones that are specific to the justice system here in the United States. They're afraid that they might be afraid that if they cooperate, that they could actually be deported or removed from the United States. And so that might be a reason why they're uncomfortable. If the person who committed the harm is still here, or if the kid received threats, then there's a fear that if they cooperate, that they're going to be harmed. There's also a fear that they might be perceived as a wrongdoer, or might not know how the court system or the police work, and they might be they might be living in a country where the police played no role in their safety and may have been cooperating with the persecutor in their country, and so they might not necessarily treat police with the same type of warm embrace that another person might. They might not know that they have certain rights to participate in the investigation or the prosecution. And the language I've already mentioned, they might not necessarily feel comfortable speaking with the police because of a language barrier between them. If the kid was harmed based on somebody upon whom they depend, then there's going to be a dynamic there that will just take some finesse to understand and to be extremely mindful of, and particularly if it might be the sponsor who committed the harm. There's going to be just more this a higher degree of care that'll be necessary there. Family pressure to keep quiet, is particularly if there's been severe harm committed, then there might be basically an urge from other family members to not report. No transportation or childcare. Those are things that just to be aware of when preparing the case, that they may have trouble with getting around or arranging childcare. The declaration for a U visa should also overlap somewhat with the SIJS one and an asylum one, where you give an overview in the beginning of their life from birth to present, so chronological, if you're going to focus on describing the declaration that way. What life was like in the home country, why they left. It's important to give those details up front, even though the elements of the U are going to be more based on what happened while they were living in the US, I think the declaration in this context is basically to give the adjudicator a broad overview of who the kid is, and not necessarily just geared toward the elements of the journey to the U.S. and life in the U.S. The perpetrator's a family member, an intimate partner, life before the crime occurred. So thinking chronologically, what was life like before? The crime itself should be a significant part of the declaration. And one thing that I do is I dedicate a time to just focus on the declaration, on the parts that have to do with the crime itself, and not necessarily dedicate my time to writing all of the declaration, just because I want to spend as much time being explicit on what happened. If there are any corroborating documents, if you have those with you, then just be consistent in describing what happened and keep it clinical, like I've mentioned. The effect the crime had physically, medically, emotionally, because one of the elements is that they should have suffered severe psychological or physical harm, then that's going to be relevant with respect to the claim, but also to just depict them as someone who had a particular life before the crime happened, and then the crime had an even greater significant impact on them. Again, to tug at the heartstrings, to focus on things that have nothing to do with the claim itself, but also just depict them as a dynamic person. If they're working, if they're in school, if they have kids, if they volunteer somewhere, to show that they're a survivor and have no interests that have nothing to do with the crime itself. What would happen if they were forced to return? What resources would they basically lose access to if they no longer were in the U.S.? What if the prosecution is ongoing, that they wouldn't be able to continue participating because they wouldn't have access to the internet and wouldn't be able to participate remotely? And so practical things like that. I generally avoid discussing drug use and self-harm because those tend to be pitfalls in the claim. You might inadvertently trigger grounds of inadmissibility if you talk about self-harm and drug use. So just minimize those where possible. If there is a criminal history or a juvenile delinquency history that you are almost certain that USCIS will get a hold of, then focusing on the rehabilitative aspects of those experiences would probably be as useful, knowing that you don't want to put them front and center in the declaration, but you're not ignoring them outright. So that way you can also just say, like, I'm seeking these forms of treatment, and I'm no longer the person who I was 2, 3, 4, 5 years ago when I was in the middle of all of these crises. Details, explanations paint an image of what happened in a way that accurately captures the intensity. That goes back to interviewing. If you feel comfortable asking for those details, then I would make pretty copious notes about what those details were, cross-reference them with any supporting documents, and then paint an image. You're describing something that happened. Be as explicit as possible, so that way they know that that you're describing something very clearly. Plausibility is something that comes up every now and then, particularly if they're describing something that you think might not be as believable. So if the kid says something like, there were 100 people who surrounded me, well, it might be sort of difficult to conceptualize that many people. So just be mindful of things that an adjudicator might be left with scratching their head. Well, how do you know that there were that many people? Or can you find a way to describe it differently so that you can still describe the incident, but not necessarily give that level of detail? Create a timeline if it's going to be chronological. Working with templates, Yeah, I think templates are a good idea if this is something that you're doing for the first time, so that you can get an idea of what's happened before, but don't over rely on them. I think that there might be a tendency to sort of be reluctant to talk about something that you think is going to be super helpful. And if you don't see it in the template, you might second guess yourself and think that you shouldn't put it in. Or if there's something in there that in the template that you didn't think was relevant, but you're trying to force your client to talk about, I think that that's also similarly problematic. So I would use them basically as a starting point, and then as the facts tend to unfold, then you adjust based on the case itself. When to submit, you might not need to if you feel like that if this is something that you could proceed without the declaration, but if it's going to be something that you mail and you never see an adjudicator in person, then you'll have to submit it at a particular time. If you're going to be before a judge and there's a hearing scheduled, then I would comply with the deadline and then update the declaration where needed. If circumstances have changed, if new facts tend to come up, then just mention those toward the end or wherever you think they might be relevant. When you submit the declaration, if you know a hearing is going to be on the horizon, then practice the direct and the cross just to know how some weaknesses can be identified, how to address them, and also to emphasize strengths to make the case stronger. You want to focus on things in particular. One thing I didn't mention here is that I tend to use head notes in my declarations to basically put them in all caps and bold, and they could be simple, like introduction, or you mentioned one of the elements, like you mentioned past persecution. I think that's fine. But you could also be more specific to the case itself. I was a student protester in my home country, and that way that the adjudicator knows exactly what you're going to talk about. Or in a you context, I was the victim of an attempted murder on X date, and that's a clear signal that you're going to talk about that particular thing. In fact, that might be a good way to organize the declaration up front, like capture the elements, and then once you're done with the first draft, then maybe revising the head notes, the headings to be more eye-grabbing than just like one or two words would. Too much detail we've mentioned could lead to an adverse credibility finding, or just a head scratch about why you know so much. Too little detail might not be enough to support your claim, so you have to find some balance. And if you can find another staff member who could review your declaration, to have just another set of eyes who could give you some feedback, might be a good thing to do, especially if you've been doing this for several weeks or months, and you might need another person to give you some feedback. Irrelevant information, I mean, I consider something that's irrelevant that either is not discretionary whatsoever, or is unrelated to the claim whatsoever. So just be mindful of things that you think won't convince an adjudicator of the positive discretion that you think your client deserves. It's important to include damaging information up front so that the adjudicator knows that you're not basically trying to hide or run away from it, to know that you're in a position to talk about it up front. And so what happened and what steps you took to be able to address what happened, especially if the client has had some type of criminal history here in the US. You don't want to run away from it, because they might have access to the evidence, and if you aren't forthcoming, then they might think that you're either not willing to accept responsibility, which is a phrase that I find very suspicious. I just don't think that you've accepted responsibility for what you've done, or that you are afraid to talk about it. Overgeneralizing. Universal language is suspicious in this area. Always, never. Those things are highly questionable, avoid using them as much as possible. Yeah, give clients leeway with dates if they're unsure of when something happened, particularly if it happened either a long time ago or it happened so often. The dates might not necessarily be as relevant. I would probably try to jog their memory by talking about relative time, like what season was it? Who was living with you when it happened? And not basically to tell them to pinpoint what month, day, and year did this happen, because number one, if you include that level of detail and then they're cross-examined and they're not comfortable with giving that detail, then that might be impeached on an inconsistent statement. An agreed upon translation for keywords. Particular words might not necessarily translate one-to-one from English to Spanish, so or from English to another language. And so if there are terms that you want to use in particular, then you might want to review those with the client to make sure that they've been accurately translated. There's a plethora of resources in this area to learn more about how to prepare declarations. The first one I think of is that TA library, the Technical Assistance Library. If you haven't relied on their resources, I would highly recommend that you do that, because they have webinars, country conditions, expert declarations, toolkits, bibliographies. Just that would be my first go-to. And when you're trying to prepare this declaration, there are also a number of centers that work with kids who have experienced high levels of trauma. And so I recommend reaching out to them. Anyone have any questions on the presentation? Well, I'm Javier. There's my contact info. It's also in the PowerPoints that you can find in the symposium website. And thank you very much for your time. I really appreciate it. And you all have a great weekend.